Good morning, everyone. Thank you for joining us for the Medical Board of California Panel A meeting pursuant to the provisions of SB 189. This meeting is being conducted via WebEx. If you are having difficulty hearing the audio of this meeting using your device, please click the ellipses button at the bottom of the WebEx application or the audio and video menu item at the top of the WebEx application, and then select Switch Audio. You will see an option to call in and will be provided with a telephone number, access code, and attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you joined the meeting with. By using this method, if you are having audio problems with your device, this will allow you to hear the audio of the board meeting through your phone. Please see the instructions on how to connect link on the last page of the meeting agenda for step-by-step WebEx instructions, including screenshots. Thank you. Ms. Liviano, you may now start the meeting.
Thank you, Angel. Welcome to today's meeting. My name is Lori Rose Lubiano, Chair of Panel A, and I'd like to welcome two of our newest members to Panel A, well, a return for Dr. Bolat. And so our first agenda item is the roll call.
Dr. Bolat?
Present.
Dr. Hawkins?
Here.
Mr. Rue? Mr. Rue? Dr. Sai?
Here.
Mr. Watkins?
Present.
Ms. Lubiano?
Here.
Mr. Rue? I see him there.
Present. Sorry, I went to go get coffee.
Okay, we have a quorum.
Thank you. Our next agenda item, number 2, is the oral argument on non-adoption of a proposed decision for Dr. Bryan. And so now I'll turn it over to our administrative law judge, Judge Wong.
All right, thank you. Good morning, everyone. I apologize for my tardiness in getting into the meeting. Thanks for your indulgence. So I believe I see we have a court reporter. Can the court reporter hear me okay?
Yes, I can.
Thank you. And are you ready, Madam Court Reporter?
I am.
All right, let's go ahead and go on the record. So we are on the record before the Medical Board of California, Department of Consumer Affairs, State of California, in the matter of the first amended accusation against Washington G.B. Bryan, the last name spelled B-R-Y-A-N, the second M.D. It is agency case number MBC 19-2012-225-266, OAH number 2019-100492. This is the date, time, and place set for oral argument in the notice of hearing for oral argument. My name's Corin Wong, and I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over the hearing. First, to ensure a quorum for the record, I ask that each panel member respond audibly after I call his or her name. Ms. Lubiano?
Here.
Dr. Hopkins?
Here.
Dr. Bolat?
Here.
Mr. Rue?
Present.
Mr. Watkins?
Present.
And Dr. Sai?
Here.
And let the record reflect that a quorum is present. Next, if I may take the appearance of the Deputy Attorney General. Do we have anyone present from the Attorney General's office?
Angel, will you please promote Claudia Moorhead
Yes.
and also Dr. Bryan?
Hello, good morning. Deputy Attorney General Claudia Moorhead appearing on behalf of the complainant William J. Prasifka, Executive Director of the Medical Board of California.
Good morning. And Dr. Bryan, are you able to hear me?
Yes,
And Dr. Bryan, are you representing yourself during oral arguments today, or do you have counsel?
I'm representing myself.
Very good. Thank you. All right. So the board in this matter has issued an order of non-adoption of a proposed decision by an administrative law judge and has decided to determine the matter itself. The board has issued today's notice for oral argument and has specifically limited oral argument to whether the proposed penalty should be modified. The following process and time limitations will apply. First, respondent has 15 minutes to make an opening argument. Ms. Moorhead then has 15 minutes to provide a responsive argument. Third, respondent will have 5 minutes for a closing argument. And finally, Ms. Moorhead will have 5 minutes for a closing argument. These time limits will be strictly enforced. The arguments shall be based only on the existing record and shall not exceed the scope of the record of duly admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify arguments, but may not ask questions that would elicit new evidence. Either I or any panel member may ask a party to support that party's oral argument with a specific citation to the record. At the end of oral arguments, I will offer Dr. Bryan an opportunity to address the panel regarding penalty. And if he elects to take that opportunity, I will place him under oath. After oral argument, the board will go into closed session to deliberate, so the parties will not receive a decision today, but will receive it in the mail sometime in the future. Please remember that all arguments must be based on the existing record and no new evidence will be heard. And also keep in mind that if any briefs were submitted prior to argument, the board has already had the benefit of reading those briefs. First, let me check. Dr. Bryan, any questions about the process?
No.
Okay, so with that, whenever you're ready, you may begin with your opening argument. Okay.
Good morning. I was here today to have an opening argument in regards to this matter. In the matter, I did not feel that the board should have anything greater than a letter of reprimand in this case. The federal court found that it was not related to medicine or the practice of medicine. Here we had in the administrative law judges meeting, we had two people that testified, one being the IRS agent Glover and another one being Dr. Thatcher, both of which have zero knowledge of my practice and said that during the administrative meeting. So that they have no personal knowledge of my practice. They did not review any records, which was not known to me until they stated that at the administrative law court. So basically we had two people that have never reviewed an email, a medical record, or any document in a medical practice to make a basis, a factual basis that I had any deviation from the standard of care. Factually, they both made inferences. Both of the people had zero experience in this field. Margaret Thatcher had not been an expert on any case. She had many misstatements. One of the biggest misstatements was that she judged the criteria of my medical acts based on articles that happened years after this period. In other words, there's no way to review those articles prior to them being written. Likewise, the IRS agent didn't review a single piece of evidence, he said. He also stated that the video that was shown was not in regards to the trial evidence, that I did not remember or recall any of the deposit type relations, which was true. In the factual case of people that actually worked in my office, the nurse, I'm sorry, I don't have her name right now, but she was the only nurse that testified for the government. She had at no point did I deviate from the standard of care. And she's not a person who was groomed by me. She acted independently. We have no communication. And she said explicitly that every single patient we saw, and according to the standards of care of practice in California, as well as I voluntarily submitted prior on a order of probation to be monitored by the physician enhancement program. Once again, they also sampled the independent sampling of patient records, in which they found that my medical documentation and care of patients was exemplary. And those are really the factual matters. I did have a conviction, which I admitted in court and which I accepted. I did have a matter of being on probation, which at this point is completely fulfilled. I took all the courses and recommendations from the federal government in forms of taxation that I submitted to the administrative court. And I did not owe any fines or penalties. All of those were paid during the period. And I have not had any problems with the medical board for over 10 years now, post this IRS conviction based on inference. And I just don't believe that an inference from people that have no factual basis of you can trump as a factual matter of the standard of care based on a zero knowledge of my practice.
Thank you, Dr. Bryan. I just wanted to make sure you finished your argument rather than are taking a pause.
Actually, I had finished. Thank you.
Very good. All right, Ms. Moorhead, whenever you're ready.
Yes, good morning. It's the complainant's position that the penalty should be modified in this case to revocation. The first point is that respondent isn't a candidate for probation. He engaged in a dishonest course of conduct, not just by structuring the transactions at issue, but also by committing dishonesty when he was dishonest with Special Agent Bryan Glover about accepting large sums of cash in his business. His conduct resulted in a felony conviction. It was committed, the criminal acts were committed for over 1 year while he was on probation with the Medical Board of California. There is a lack of rehabilitation evidence, and there's minimal mitigating evidence. Our introduction summarizes really well our position in this case and supports the reasons for revocation in this case. Second, the ALJ did indicate that the complainant didn't establish that respondent was running a pill mill, but it did find that the complainant had established that the respondent had sustained a substantially related felony criminal conviction. And the ALJ also found that he engaged in substantially related dishonest acts. Those are findings that the respondent cannot dispute, even though he's doing so here in his oral argument. Those are findings that have been already made. So the main issue today is whether or not the penalty should be modified. The disciplinary guidelines recommend that revocation is a penalty for both types of findings, for a felony criminal conviction and for dishonest acts. So revocation is an appropriate penalty in this case. Third, placing the respondent back on probation under the same type of monitoring that he was under in the past doesn't make sense. It's not an appropriate way to protect the public and to assure that respondent is in compliance with the law and probation. As I stated earlier, he committed the crimes for over 1 year while he was on probation. He was being supervised by 3 different professionals: a billing monitor from the PEP program out of PACE at UC San Diego, a practice monitor from the PEP program. And this type of monitoring is more hands-on, in-depth monitoring than had respondent hired a independent practice monitor. So this is the highest level of monitoring that a physician can have. And he was also being overseen by the board's probation monitor. And despite being overseen by 3 different professionals, he still committed the crime at issue. I want to point out that a billing monitor doesn't oversee financial aspects of the business. All that a billing monitor does is review medical records and see if the doctor's medical coding for the procedures performed is appropriate for submission to health insurance companies for payment. And this case has shown that respondent's business was cash, mainly cash. So he would have to hire a financial forensic accountant, a forensic accountant to review how payment was received and processed. But a billing monitor doesn't have the ability to do that. And the medical board simply doesn't have the resources to be able to assure that the respondent is in compliance with his probation and with the law. This second time around, if the board was to put him back on probation. And it's our contention that the respondent cheated his way out of probation. He doesn't like attention from the government. He doesn't want attention from the Medical Board of California. So revocation is the only outcome that will protect the public from respondent's dishonesty, from his, which is demonstrated by his felony criminal conviction, commission of the crimes while he was on probation, and he committed them for over 1 year while being supervised by 3 different professionals. There's a lack of rehabilitation evidence and there's minimal mitigating evidence. And so for that reason, it's our contention that revocation is the appropriate penalty in this case.
All right, thank you. Dr. Bryan, your final closing argument.
Yes, revocation is completely inappropriate in this case. I was not found guilty of any dishonest act. My medical practice was never named as a defendant or found guilty of this practice. This was a combination of funds that were received from me at different locations that were delineated to the court, and the total amount, which was not known to me because I do not collect funds at parking lots or at commercial buildings. All I received was a notice of a deposit, and it wasn't something that I acted outside of the course or aspect of a physician. I hired competent attorneys, accounting attorneys, law practice, competent forensic accountants, of which Ara Kasabian, which is listed as my accountant on my federal case, is a licensed qualified CPA, financial advisor, as well as a medical business administrator who monitored and submitted my billing. What more could a physician do than hire qualified people at the master's degree level to do this sort of work? And, you know, it's not that I was trying to deceive at all. The court did not find that in any manner. They found that it was only inferred, you know, merely inferred. The judge told me specifically that I had done nothing illegal. Nothing. He said, this is an inference. In terms of the monitoring, I cleared up every aspect of what I was on probation for, and I completed the probation successfully. During this period, the medical board, I guess, had also referred me for a criminal investigation. This was unknown to me. Even with all of that, I eliminated all of these things from my practice without not even getting a notice. I actually felt that was, you know, the medical board representative said that they did not disclose it to me because it was an active investigation. But how can someone correct something that is not stated? And I'm paying a great deal of money to be monitored and whatnot. It seems like it's a disservice to the physician to have something that is known that could be a possible, at that point, problem in the practice and not have that corrected at the time. You know, and these are not employees of mine that collected the fees. Therefore, they're with a separate company that I do not control. You know, it's not a matter of my employee who committed an error. It's a separate company collected a fee and then deposited it, and with that, and I don't see how that possibly could relate to me. Now, if you take the total of my medical practice, which the accounts are clearly labeled, I don't have a single incident of having structuring as a course. But, you know, considering my investments, my commercial properties and whatnot, yes, it had come in over 10,000, but it's not something that's known. And no one that I have approached with this has ever heard of this. And the basis of this conviction is Claudia Moorhead stating that you have the medical board has a financial clause, a law that she was unable to establish. I've went to court now 1, 2, 3 times with Claudia Moorhead saying that the board has financial rights. I have no physician that the board has monitored their financial relations, no physician that they've monitored their tax investments or the course of real estate. It's just something that is untrue. And in that matter, I felt that Claudia Moorhead had a responsibility as representing the medical board that she should have reported that to the federal board, which she was named as an attorney. You know, Claudia Moorhead falsified the law. There's no law in the medical board that I broke of structuring financial statements. Without that statement,
Dr.
it
Bryan?
can go to court.
Dr. Bryan, your 5 minutes have expired. Thank you
Yes.
very much. Ms. Moorhead, your final closing argument, whenever you're ready.
Sure, Your Honor. Just to start with the first argument that that respondent mentioned, something about having a qualified individual with master's degree in accounting. There was, in our hearing, there was no such evidence, and no such evidence at the criminal trial. The respondent can't impeach the conviction. The conviction is what it is. It's done, and the court can, the medical board can take action based on a substantially related criminal conviction, which is what the Office of Administrative Hearings in this case found is. The ALJ specifically found a connection between the crime of structuring bank deposits and respondent's pain management practice. The court did indicate that there was a high probability that his pain management clinic was a major source of the cash, and that there was a high probability that he structured deposits to avoid raising suspicions about his pain management clinic and why it generated so much cash. So those findings are in the decision. They have been made. The court also made a finding of dishonesty. So the respondent is incorrect that there was no finding of this dishonesty in our case. And, you know, so dishonesty is at issue. And an example would be tax evasion. The medical board can discipline a physician for tax evasion. The structuring of transactions is a very unique crime, and in the sense that there's minimal case law under addressing structuring of transactions in the context of, you know, medical board proceedings. But in many ways, it's similar to tax evasion, and involves dishonesty. So so the respondent is incorrect in that sense, and she's making representations about what I should or should not have said. Anything that was said is thoroughly documented in the administrative record. There was no falsification of facts or law or anything to that effect. And at the end of the day, we have two key disciplinary bases, which is a substantially related felony criminal conviction and dishonesty, and as well as unprofessional conduct by virtue of those two findings. And for that reason, complainant submits that the appropriate penalty is revocation. Thank you.
All right, thank you. So next, before I offer Dr. Bryan an opportunity to address penalty, I'll ask the board if there are any questions for the parties.
I have a question.
Okay.
Thank you. Dr. Bryan, I wanted to know if you could, in your own words, if you could summarize for us the steps you've taken towards rehabilitation.
I've taken substantial steps toward rehabilitation. I voluntarily entered the physician enhancement program. I successfully completed that after this event period. I was found to have excellent records. I attended, you know, basically it's like a university in Colorado of courses on financial transaction management in a work camp where I was monitored with that and took these courses for the courses of 2 years. I got monitored in post post being imprisoned, and during that time they monitored all of these financial type transactions, and I was found not to have any problems or anything that extended my time. I completed everything successfully and did everything that the court asked. And in terms of rehabilitation, this is not a crime of recidivism. It's not a crime where people repeat it. It's the lowest incidence of repeat offenders. This is something that you kind of get shocked that, as I was, that you would take every business that I own a portion of, and then you would do the cash transactions and say that, let's add them all together. I've never heard of that. And I think in terms of recidivism, this is almost a zero recidivism thing. This why there's no case law that Ms. Moorhead can refer to in terms of the medical board disciplining people for this thing. I did everything that the judge ordered me to do. It took I'm talking 2 to 3 hours a day, every single day going to class. And I gave, it's a simple line in the record, but it has the courses and whatnot that I took that were required of me by the judge. It basically was like going to college again.
Dr. Hawkins, may I have a follow-up on that?
Please, Dr.
Go ahead,
Hawkins.
doctor.
So thank you for that, Dr. Bryan. So we're aware, and you've repeated to us, that you followed all the recommendations that you were required as part of your the discipline. Do you have anything else you can tell us that you've done beyond what you were required to do that might speak to your character?
Definitely. I have numerous amounts of public service, charity. I've not had a single patient complaint here, not a single patient in this case was brought to testify against me, not a single pharmacist in the state of California. I've not been reprimanded by any hospital boards. I'm considered a standing member of ethics committees and whatnot, and I'm a valued and member of the community. I've served as chairman of the West LA Healthcare Fair over 4 times as being the top representative of healthcare in Western Los Angeles. I've also served on the board of directors for the Chamber of Commerce. I mean, I'm a respected member of the community that goes, I donate time every single week to the care of people with COVID, food type things. It wasn't by accident, and for us really to say that, on a supposition that I've done quite a few things. I've received numerous awards in the time period since then from the American Medical Association, the Key to the City of Los Angeles. I work tirelessly in the community to make this a better place. I had an error. I had an omission that did not require a knowledge of me doing anything illegal. Read the definition of what the law is. I mean, it's something that was factual that has almost no basis of anyone repeating it. This is what it was. I had the penalty. I served it. And since then, I've done everything in my power to mitigate this, including giving free consultations since this period, since I've been released for medical care, not charging a dime.
Thank you.
Any further questions from the board?
Yes, I have 2 questions.
Please go ahead.
Dr. Bryan, you mentioned that you have this impeccable record during probation. So on page 537 of the transcript, I saw that for the period January, February, March, April, May of 2013, you did not submit those chart notes that was requested from you by the PEP program, and you were subsequently suspended for a period of time. So how do you respond to that happening while you were on probation and still claim an impeccable record?
Well, during that probation, and you have to recall, and maybe you don't recall and you don't have to do it, but during the testimony of the two people, of the administrator of the PEP program, he said, I was well within the guidelines. The other thing we don't have from the PEP program is what their decision-making was in the emails there. The thing that happened between me and the PEP program is that I was on probation for prescription writing. The monitor wanted me to basically be monitored for surgical procedures, doing certain X-ray and fluoroscopic studies that were delineated in those emails that the PEP program said they now, at this point, this many years later, can't provide. So in the term that they made that decision on what exactly I was required to do, the person that actually was found to be asking something that wasn't required of me was Dr. Leung, which they strictly wrote that he had no basis to ask me to go to take courses outside of the state and to require me to get licensing for pain management facilities. Now, I do have to say this, in the record that's submitted from the probation monitor, it has that I did all the courses that he asked me. So I actually did it, and that's how I was reinstated. But they actually, the head of the physician enhancement program, I don't recall his name, but during, at this point, but during his he commented that those records weren't available for them to produce now 10 years later. But what they found is they thought that Dr. Leung asked me to do things that were outside of his scope. And I actually did get the fluoroscopy licensing. I did take every surgical course that he recommended. It was felt by my representative, who's also a pain expert, that it was more a matter of semantics. And I did not try to argue semantics. Dr. Leung has his certifications through the American Society of Interventional Pain Physicians, or actually he has his through ISIS, International Spine Interventional Organization. And I have mine through a group that's a different pain organization. So we have different conferences that we attend. I actually did the full complement of courses demonstrating my skills and techniques to the licensing board that he preferred. And I successfully completed those and submitted those. Now, there was one issue that I was not able to resolve with him, that being, and he still stated it even this time, was the matter of the fluoroscopy. The licensing in California takes quite a bit of time to get an official certificate. So even though I had credentialed to have the fluoroscopy in my office, in my pain management practice, he said that I should not even being authorized to do it until I physically received the certificate, which took over a year and a half. This was a new facility that I was at. It wasn't at, but I had moved my office in March of 2011. So the credentialing criteria, we moved into it, but that wasn't completed by the time that this probation was completed. But it was not a term that was required in my probation, but it was something that he thought a pain physician should do. I actually don't have the same opinion that he does on those procedures. Yes, I can do those procedures. Yes, I am credentialed to do them. The facility where we were at was not currently had a plaque to hang on the wall. That could be checked with the Department of Consumer Affairs that I met the credentialing. But after that was returned, I gave them the documents that they gave me. He reviewed those and they removed the suspension because I had submitted all of the paperwork with the physicist reports and whatnot to do the work, and they had signed off on it. They merely were not able to send me the certificate to hang on the wall that he said that he would want it prior to me using that facility.
So if
May
I'm
I
hear-
be, I'm sorry.
so if I hear you correctly, Dr. Bryan, the reason why you did not submit was related to these other procedures. So the record indicated it was for not doing the initial consultation at the when you know, on the intake of these, and Dr. Leung wanted to see those. Is that correct? Because you explaining something completely different than what I heard in the record.
Okay, that is not correct. What we had during this period is Dr. Leong is used to a period where you can draw up 10 years of records. We were on a different patient management system. We only had records available as, it might have been 5 or 6 years. It wasn't 20 years of records that was available at this time because of the change of the software program. He did not receive those till we were able to print those out on a separate system and submit them to him. And he did find those to be relevant. Now, when the records and whatnot are requested, it actually goes through the personnel at my office, doesn't go through me. So when they asked for records that weren't on our current system, it necessitated us restarting that software program and then printing those out, but also redacting those. It was actually quite an extensive process to reoperate a system that we had no longer used for, let's say it was over 10 years. But he did receive all of the records, and none of those were found to be deficient when he received them. It was just a matter of there was no way to print them out from our current provider, which was Cerner, from our old provider, which I believe was MetaNotes.
My final question, Dr. Bryan, is at the beginning, you said you did not feel that the board should issue more than a reprimand because you feel that this structuring conviction for which you spend time in federal prison is not substantially related. So does that mean you don't consider it a dishonest act?
Actually, the judge said it was not a dishonest act, that it was not a legally thing, that in this case, they thought that if I saved money up till Friday and then submitted it at that part, that would have triggered this report that gets made. But we've never had a practice of saving monies, receipts, or checks to once a month or whatnot. And actually, after doing that, we proceeded to do that ever since they said that. So it wasn't a matter of what we did as a service. We never were ordered to change anything that we did in my medical practice or any procedure other than instead of making deposits daily, which I don't save checks we receive from people. We run the credit card machine every day. We did what the court asked us and we submitted to that. And we've never changed since that point of depositing only when we have deposits greater than the structuring, the requirements, which was $10,001. That is actually something we had never done. And I did that with everything that we do. So commercial buildings that we have do not make deposits, store that till we have amount that's greater than this reporting requirement. So it's not a matter of you doing something that's illegal. It's a matter of the people that work for you after they collect things that they can't, perform their duty of depositing till after a period of time that it's above this limit. I don't know if other physicians do that, but, because this was brought to my attention and I was convicted of it, I did it. I bought a practice from another physician. He never was accused of this. The physician that owns the practice currently hasn't had any problem. And as far as I know, they haven't changed any procedure. I mean, in terms of, we were in this terms of, we don't save checks and whatnot because we don't know if they'll be good at a certain point, and we did not have facilities for saving payments at our facility. We didn't have that capability. So we merely deposited, the worker would deposit the money on their way home. They got drive it to the bank and deposit it. We did that on a daily basis.
Well, thank you.
Your Honor, am I allowed to comment on some of the things that the respondent has indicated?
No, unless there's a question from a panel member.
Okay, thank you.
And I'll ask Mr. Watkins, did you want the benefit of Ms. Moorhead's response in answering your question, or did you get the information you needed?
Yes, I would like to clarify some of the stuff that is, confusing to me pertaining to first the January to May records. And also, if it was all just a big mistake and it's not substantially related because it was his ordinary course of business, I would like that to be clarified.
Okay, and I guess the one caution I would add is substantial relationship has been already determined, and so that cannot be impeached. But if with that guidance, Ms. Moorhead, if you'd like to respond.
Well, the point that I want to make is that the record doesn't reflect that Dr. Bryan was asked to provide records specifically with respect to his fluoroscopic and X-ray part of the practice. Basically, the correspondence from the PACE PEP program showed that he wasn't providing any patient records for review during that time period. So for him to say that it had to do with his fluoroscopic and X-ray part of the practice is incorrect. Ultimately, he did submit records, but there was a delay of several months, and I would note that there's a constant issue and excuse for not providing records. I will point the court to the citation that he received, although it's not discipline, but it's just an example of how he in the past, didn't produce records when he was asked for them. Now, he did receive the citation and he did not admit to the truth of those facts, but there's, a constant excuse for not providing records. And we see it again in this case where he wasn't providing records for several months to the PEP program. And these are records of his patients in general, hadn't, without any, request for a specific type of record. We also brought up in court that that when the practice monitor made site visits and he was waiting for Dr. Bryan to provide full and complete medical records, those weren't made available to him for review. And Dr. Bryan couldn't provide an explanation for why those records weren't made available. And that is in the reports that the practice monitor had provided. So there's a constant blaming of a software, program and the company that he had, but that excuse can only get him so far. And I won't address the substantially related argument because, as the court said, that has already been determined, and the only issue here today is what is the appropriate penalty to impose.
Great, thank you. Any further questions from the board?
I have a question.
Go ahead.
Dr. Bryan, if the medical board decides against revocation, what are your future plans in medicine?
Hello? Can you hear me? What I would plan on doing is continuing doing what I've been doing for the last several years. Continue doing consultations, continue being an expert in my field, continue to be participating with the community. I did not ask the board to restore my narcotic writing license. I voluntarily submitted that as a mitigating factor as well. I'm looking just to take care of clients and whatnot. And I mean, eliminating cash deposits from someone's practice is something that's very simple to do. And, it's something that's easily monitored and whatnot. And in terms of Claudia Moorhead saying it's a danger to the community, this is something with no recidivism. It just doesn't fit into that. So I would like to continue to run my consultation practice, to be able to be run medical facilities as I have in the past. And, I'm not really much of a clinical person at this point in my career. And, I'm not looking to have a hospice or palliative care type practice anymore. I've resigned that portion of my practice, and I had resigned that prior to this conviction. And I'd like to continue with my integrative medicine and the services that we provide to the community, such as acupuncture, weight loss, and motivational interviewing, which we do not require any narcotic writing or anything like that. I do not have to have payments in cash. That was something that a separate company took that this employee worked for. That's not something that's part of my basis. I care nothing of how a person paid for a consultative service. I never even checked, and that's my fault. It just never came to my mind that could be a problem for me. But going forward, that's what I would like to do, to be able to practice medicine. I'm not going to be writing narcotic prescriptions. I'm not going to be involved in hospice, palliative care, pain management. I like to continue my integrative practice, which is mostly concerned with nutrition, acupuncture, and motivational interviewing, which is the lion's share of my practice. And previously, with the board, I did submit documentation of my board certification in those fields. So the board is aware of my training in those fields. So I'm not looking to go into the pain management. We had different ideas of what, in terms of practice and those things. I'm not looking to repeat that. I don't want to put my family through that ordeal again. I don't want to put myself through that ordeal again. So I've, voluntarily do not accept cash payments. They do not write prescriptions for controlled substances. And I think that more than puts the community, the public at, not at risk. I mean, and as well as in this case, I had no patient that was harmed. There was no one that the Moorhead was able to find that I treated inappropriately. Not a single factual patient, not a single pharmacist was that. That's why it said that it was inferred, that there was not a single case. I mean, not a pill mill, not a single case of which the medical board had a patient, a pharmacist, or anyone in the medical community that said that my patient was below the standard. They might have said that they ordered records that that are serial reviews with Dr. Leong that come from years past. But, I've been in practice 30 years. So we do not have the same systems in place. It's not something, yes, for every time you ask me for a record from 1997 or 2000, I'll have to do the same thing. And we try to get the computer running and, that. It's not that. It's just not our current system of records. And they make computer records extremely difficult to transfer to a new system because they don't want those records copied. Another thing that's what was done with future practice, the reason for the monitoring and the insurance practice was to see that if I changed anything in terms of the records, the records were completely the same between what the medical board received and what I documented, what the fees were. There was nothing that I tried to hide from them. And going forward, I'm not going to have any of those issues. I'm not looking to run a cash-based business. I'm not looking to accept any payments other than credit cards and those sort of things that we've accept. And
Okay,
I'm looking just
Dr.
to
Bryan,
interventional. Yes.
I'm going to interrupt you here. You're starting to repeat yourself, and I think you've gone
I'm sorry. Then I
well
will.
beyond the scope
Thank you.
of the question. Any further questions from the board? All right, hearing none. The regulation does specifically give Dr. Bryan a chance to address the penalty under oath, even though that's what argument was limited to. So I will give him that opportunity. Dr. Bryan, if you want to specifically address, if you want to say anything under oath about penalty, I'm going to limit your comments to 2 minutes, since that was the purpose of oral argument already. Did you want to go ahead and take that opportunity?
Yes, please.
Okay, so let me go ahead and swear you in, even though if I can't see you, if you could go ahead and raise your right hand.
You cannot see me, or I wasn't aware of that.
Yeah, no, I don't see you, but it could just be that it's not up on my screen. Do you
Well, my hand is raised, and I actually thought you guys could see me.
Oh, okay. Do you solemnly swear or affirm under penalty of perjury that the testimony you will provide in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, go ahead and put your hand down, and I'll go ahead and start your 2 minutes.
It's just my feeling that in similar situations, the board has not revoked a licensee's license for similar behavior. I can't recall the person specifically now, but they've given letters of reprimand for things that have been ameliorated. In this case, I no longer, as an agreement with the federal system, I did not take any more cash payments, so that stopped immediately, even before this conviction. And going forward, I would like just to have a plain practice that doesn't involve any of those areas. I've not had any complaints in 10 years, and I think that warrants in our current condition to be able to practice medicine. And a further mitigating factor is I completed the entire probation from the federal courts. Yeah, I did everything that they asked for me, which wasn't true in that. And further, for 3.5 years, I've waited for this event. That seems excessive to me, that I've had this thing on my license as being questionable for that amount of time, that supposedly that's what this law was supposed to avoid. That we would let people that, had an opportunity to practice without having them undo penalties that, for 3.5 years, I've been, under this when there was no reason to delay this for 3.5 years. They could have had this when I was released or before. Thank you.
All right. Thank you, Dr. Bryan. And then I just wanted to check if any board members thought of any questions based on Dr. Bryan's last comments. I'll provide an opportunity to ask those at this time if there are any. Okay, so hearing none, that concludes arguments in this matter. So the record's closed, the matter is submitted, and we are off the record. So the panel will, well, let me do this. I'll turn it back to you, Madam Chairwoman. to proceed, whether you want to take a break now or go to closed session. I'll leave that to your discretion.
Thank you, Judge Wong. I think we can go ahead and proceed to our closed session. And so we'll have to get off this session and dial in on the other one. Angel, any other instructions?
Closed session currently the meeting for the closed session is currently open. So if you guys want to go ahead and disconnect from here and then just click on the link for the closed session.
Okay, will do. Thank you.
You're welcome.
Now returning to our open session, the last item is adjournment.
All right. Thank you so much.
Thank you.